Officer Day, would you open the courtroom for me, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Laverne Carter.
Hello.
Good morning. What is your name?
Good morning. My name is Laverne Carter.
Ms. Carter, why are you here? I don't have you on my docket today.
I believe for the Jefferson Capital Systems.
Oh,
We supposed.
Laverne Carter?
Yeah.
I don't have you on my docket today. I have Jefferson Capital System versus Lakeisha White. Is that the case you're referring to?
No, you told us to come back today on the 12th because we reached a judgment, and you was just told me to come back to make sure that that it was paid off.
They set that in already.
Okay, so
Give me your case number.
I don't have the case number, sir. I just remember that I had to come back for the court date.
Well, you're not on the docket today, so apparently they were satisfied.
So okay. Thank you so much.
Yes, ma'am. Have a good day.
You too.
Safe out there.
Bye.
Good morning. What is your name, ma'am?
Good morning, Desiree Burns.
All right, I have Mr. Burke here. Let's get you in here. Let's get you started.
Okay.
All right. Mr. Burke, good morning.
Hello, Your Honor. Can you hear me? Okay.
Good morning.
I have everybody. Let's call your case and we'll have your appearances. We can get started. This is case 22-178-096. Beaumont Health System versus Desiree Burns, excuse me. This appears to be our third pretrial. Your appearances.
Yes, Your Honor. This is Hal Burke, P69068, attorney for Beaumont Health on this case.
And your name, ma'am?
Desiree Francis Burns.
Okay. Where are we on this file, people? This is our third pretrial. Your written discovery has been open for a while.
I did. I was able to write him a letter and send it through the mail. And then I also tried again to email him. I did apologize to him that, I had the wrong email in the beginning. So it's like, I did send the letter. So where do we go from here? Because, I'm not really legal savvy, and I just want this to go away because I'm stressed out about it enough. So let's do what we got to do.
Your Honor, maybe if I could recommend maybe a quick breakout session coming back to you with a resolution. Sounds like could happen.
I'll put you two in the chat room, give you an opportunity to see if you can resolve the matter.
Thank you.
Thank you.
Hang on, let's see if I can make the technology work.
Mhm. Hello?
It's gonna be a minute.
Oh, okay.
Come up on the screen.
Mm-hmm.
Yeah. All right, she's there. And he's there. Okay. Cool. All right, we are on the record calling file number 22-183-089, United Lab RX versus City of Detroit. This is a motion to reinstate a dismissed case. Could I have your respective appearances?
Good morning, Judge Abdul Kareem Saad, P84038 on behalf of the plaintiffs.
Good morning, Judge. Good morning, Judge. John Cahalan, P77404 on behalf of defendant City of Detroit.
Yeah, Grospec RX LLC is also a plaintiff in this file. Mr. Saad, this is your motion.
Yes, Judge. So Judge, this is our motion to reinstate the case pursuant to MCR 2.401G2A and 2.401G2B, or I should say, it's pretty simple. We didn't receive notice of this hearing because if we did, we definitely would have been there. There's a few attorneys in this office. We appear to everything. In my motion, I did also attach, a notice that we do get from the post office. I want to say very often, but we do receive it that, hey, we found a piece of mail that wasn't processed correctly. Here you go. And unfortunately, we only receive that that notice when they find mail. So if a piece of mail is lost, we're never going to get notice of it. So I think this would prejudice my client because this is not to their fault. It's not to my fault. I don't think. I think this court should reinstate this case so we can litigate this properly.
Well, Counsel, what's your position on this?
Well, Judge, just the City of Detroit defendant in this matter did receive notice of the pretrial, the prior pretrial, with the case being dismissed without prejudice, the plaintiff could take other avenues to pursue this matter. So leave it to the court, leave it to the court's discretion, and leave it to the court as far as what they want to do with this. So.
Okay, Mr. Saad, I got a question.
Yes, Judge.
On the pretrial, which was sent out to the parties on May 9th, 2022.
Yes, Judge.
Received by counsel for defendant because they appeared. Has the address that we used to send you the notice of dismissal. So
yes,
you'll see why I'm confused.
Oh, I'm confused as well, Judge. Like I said to you, it must have been a USPS error because I receive on a weekly basis my neighbor's mail. There's 3 law offices down here. I receive their mail that I got to give to them. Judge, this would, I did hear defense counsel's response. This would prejudice my client because their SOL is passed. So if this case is not reinstated, then they can't refile.
Now, the exhibit that you attached to your motion, did you get any mail along with that? Or you just got the notice that there was nothing else, that something had been missing?
That notice is not for this particular case.
That's my concern.
Yes, and that's what I indicated when I was telling you about the notice. That notice is to show you that the post office does have these mistakes.
This is dated June 20th. The failure to appear was June 2nd. Okay, let me do this. I'm going to put you guys back in the waiting room. I have another matter that I was sort of in the middle of when I called you. So you guys don't go away. I'll get back to you in just a second, okay?
Yes, Judge.
This electronic stuff, it's like, I need to do better. This is crazy.
All right, let's go back on the record. Where's Mr. Burke? All right, we are back on the record on file number 22178-096. The file is entitled Beaumont Health. So where are we on this file, people?
Your Honor, we thank you for allowing us to go on the breakout session. We did reach a resolution. I'm going to prepare a consent judgment and email it to Mr. or Miss Burns for her to review and email back to me. And I'm happy to recite what we agreed to on the record if you'd like me to.
Sir, if you would.
Sure. Today, Ms. Burns agreed she will consent to a judgment for $833.50. She asked for, and I agreed that she could pay it at $50 every 2 weeks. She's going to begin that August 5th. She provided to me her information for it to be done electronically. And I'm going to put that in writing, email it to her email address she gave me for her to review, sign, email back to me, and then of course get to you, Your Honor.
Ms. Burns, did you hear those terms?
Yes, I did.
Understand those terms?
Yes, sir.
You agree to those terms?
Yes.
Okay, we have a settled case. What I will do is I will dismiss the matter without prejudice, indicating we will be looking forward to your consent judgment.
Thank you,
you.
Your Honor. Thank you.
Let's be safe out there.
Be safe. Thank you.
All right, have a great day.
Thank you.
Thank you, ma'am.
Thank you. So now what?
Now I'm going to release you. There you go. You're all set. So let's admit and admit. All right. I think we're back on 20. Oops, sorry, wrong file. Back on 22-183-089. The file is entitled United Lab and Grossbeck LLC versus City of Detroit. All right, first question I have, Mr. Saad. You describe yourself as on your motion on the notice of hearing as attorney for proposed intervening plaintiff. What's that about?
I apologize. That must have been a mistake.
Huh, indeed. So what are the data services that we're talking about here?
Let me pull those up. If you just give me 1 second.
Yes, sir.
So for Grossbeck, it's April 5th of 21.
Okay.
And for United Lab, it's April 8th of 21.
Okay. So we are now past the 1 year mark in regard to both of those services.
Yes, sir.
In terms of what your claim is, if assuming the case were reinstated, what is it that you're claiming for Grossbeck? What is it that you're claiming for United Lab?
For United Lab, it looks like it's $2,485. And for Grossbeck, it's $1,826.
Right. Anything else you want to say, counsel for the city?
Nothing further from me, Judge.
All right. Then what I'm going to do, I think that we're relatively early on in the litigation. And the situation is that if the case is not reinstated, both plaintiffs lose their claim because of the 1 year backward. I'm going to have to accept the representation of counsel that his office did not get notice of the pretrial that issue. Although I'm going to say very clearly, I have questions about that. I always have questions when someone tells me I didn't receive something that says come to the pretrial, and yet the notice of default or the notice of dismissal sent to the exact location gets delivered. I'm sure you can understand why I have questions in that regard. What I'm going to do, I'm going to grant the motion to reinstate the case if, and I need to know this answer right now. Mr. Saad, when the court sent out the notice for the pretrial, I required the parties to make the MCR 2.302A disclosures within 21 days. Did you make those disclosures prior to June 2nd?
Let's check. Did you receive them, Brother Counsel?
Did I receive these notices?
No, I'm asking about the 2.302A disclosures.
Initial disclosure, because I don't send those out. My staff does.
No, I didn't receive any initial disclosures in this matter so far.
All right. violated the terms of the court's order. But according to what you say, you did not get that notice. This time, and I can't emphasize this time strongly enough, this time, I will grant your motion to reinstate the case. I will require you to make the 3.2A disclosures within 10 days of today. And I'll give you guys a return date with me, and that's going to be August 30th at 10 o'clock. Is there anything else we can do?
Judge, I just like to mention, I would never misrepresent to this court or any court anything about. Yeah.
I'm suggesting, in view of the procedure that you described, where your office, not the lawyer, sends out the disclosure, in view of the pleading that you filed, describing yourself as attorney for intervening plaintiff, I'm suggesting structural problems in your office. I'm not suggesting you're misleading the court. I'm suggesting you have in-house problems about how you take care of your business.
All right, thank you, Judge. I appreciate the advice.
August 30th, 10 o'clock, gentlemen.
Okay, thank you, Judge.
Thanks for coming in.
Thank you.
Mr. Saad?
Judge, did you want me to submit an order to that effect, or was that not necessary?
I will write the order, sir.
Okay, thank you, Judge. You have a wonderful day.
You too, sir.
Paintings from the 18th century Venetian master Antonio Vivaldi purchased in 1952 a composition entitled Vivaldi High. He gets credit for putting this new. Giancarlo Francesco Montero made that arrangement. 19th century music of the 18th century. That's Chingo. Exactly halfway through the Haydn symphonies, this number 52, they recorded them all with Philharmonic Wildcat. Here they are. right. All the Haydn symphonies, Philharmonia, there they are. Apple Diva Collection, number 15. You know, midday music today on Metro. Tomorrow, the cooler, mid-70s expected. We are some good.
Good morning, Your Honor.
Good morning, Counsel. Let's see if we can get Mr. Fowles on. Counsel, good morning.
Good morning, Your Honor.
This is 22-177-980 Jalise Sheffield versus Allstate Insurance. Your appearances.
Joseph Falls on behalf of the plaintiff, Your Honor, P80521.
Zaina Hamadi on behalf of the defendant, Allstate, P85975.
Okay, 2.3028 disclosures have been made. What's the amount of controversy here?
Sorry, I am covering this. I am currently looking that up. I know it's under 25 and it won't go above 25.
There's no ongoing claims here.
I do not believe so, Your Honor.
Okay, so why haven't we killed this case?
Well, Your Honor, actually, I'm covering this for Mr. Haraskevich, counsel of record. He let me know that defense has scheduled a deposition of a service provider, which he will be filing a motion on.
Yes, if I could just, I'm sorry, if I could just chime in, Your Honor. We would actually like to adjourn this pretrial just because we do have the deposition of the care provider.
Let's stop right here.
Okay, Your Honor.
Is this deposition being done by stipulation?
We stipulated to the plaintiff's deposition, Your Honor. And that was the only deposition we stipped to, but then they arbitrarily noticed up a deposition of the service provider.
Ms. Hamada?
From what I'm aware of is that the deposition for the care provider is scheduled for July 20th.
That's not my question. This is the district court. And discovery is by leave of court. That'll be the guy in a black robe. That's me. Or stipulation of the parties. I know the guy in the black robe did not agree to a deposition of a service provider. So that leaves us stipulation. And what Mr. Falzon said is they stipulated to deposition of the plaintiff, and you know it's a deposition of somebody other than the plaintiff.
Your Honor, would I be able to ask if we could stipulate for and for permission to take the deposition of the care provider.
That's between, parties stipulate between themselves. And they either, apparently that's not what they stipulated to. So what I would suggest you do, Ms. Amato,
Yes.
is send out a notice canceling that inappropriate deposition. And then you get together with counsel of record, apparently someone other than Mr. Falzon, first of all, and take the deposition to which you stipulated, the deposition of the plaintiff. And then after that, if you can stipulate, and if you still need the deposition of a care provider, then either do it by stipulation or file a motion. But you can't just unilaterally agree to the deposition of Johnny, or deposition of Sam.
Yes, Your Honor.
So we'll give you guys another date, and let's get this failure to communicate straightened out. Does August 30th work for both of you at 11 o'clock?
Yes, sir.
Yes, Your Honor.
That works for you?
Yes,
Okay.
Your Honor.
Send out the notice, just adjourn your pretrial till August 30th at 11 o'clock. And you need to review, Ms. Amato, the rules concerning discovery in the district court. This isn't a circuit court. You don't have discovery of right.
Yes, Your Honor.
Thank you both for coming in. We're off the record.
Thank you. Your Honor.
Thank you. Have a great day.
Let's be safe out there.
You too.
You
Your Honor.
too.
Thank you. Okay, let's see. June 30th. Ms. Strickars?
Oh, good morning, Judge. Thank you for waiting. How are you today?
Good, how are you?
I'm good.
We are on the record calling file number 21-163073, Jefferson Capital System versus Lakeisha White. By a notice dated June 28th, 2022, and mailed to both parties. This matter is set for hearing today at 11 o'clock on the defendant's motion, the plaintiff's motion to set aside dismissal. Your appearance.
Thank you,
Go
Judge.
ahead, file.
Good morning again. Suzanne Strickhardt, P44018, on behalf of the plaintiff.
Ms. Strickars, did you get any pleadings from Lakeisha White?
I'm sorry?
Did you get any pleadings from Lakeisha White, the defendant?
No, Your Honor. No, I did not.
All right. Why should I set aside dismissal?
Well, Judge, the defendant was served on December 15th of last year. The default was filed on January 20th of this year. A register of actions indicate it went up to the judge, and it's not clear to me whether they sent it to you or Judge Robbins. Anyway, on February 1st, the defendant still has not made any move to defend this matter, to file anything. We're not in receipt of a thing. And so since service was completed in a timely fashion, we don't believe the dismissal was proper, and we're asking that the default judgment be entered.
Well, the problem that I have, Mr. Cars, is looking at the register of action. If the court, I should say me, on November 19th, I entered an order for substituted service providing for three types of service: first-class mail, certified mail, posting by a 36th District Court officer. If you look at the proof submitted thereafter, you provided proof of the first-class mailing, provided proof of the posting, provided proof of the certified mail. When your default request was sent to whoever it was sent to, I don't think it was sent to me, but these things happen, noticeably absent. You didn't have an SCRA status report. So even though you had clearly, in my judgment, satisfied the court's order for alternate service by first-class certified mail and posting, you can't enter the default without SCRA status report. When that notice went out on May 4th, 2022, hey, we're going to dismiss the case because there's no progress. There doesn't seem to be any action on your part for 45 days, and then the case is dismissed.
Yeah, because we sent a default on January 20th, and then we sent one on February 1st. And you're requiring the SCRA as scrub for any default now. Is that what you're telling me?
The default that you requested, right, that you sent.
Oh, it's not checked as to we have that the default party is not in military service, but you're requiring, and then we did not attach the SCRA report.
No, you did not.
Oh, yes. Well, I have a copy of it attached to our
motion.
Yeah. Oh, you're saying initially it wasn't attached?
Exactly. And that's why the default was not entered. Then what I'm questioning is, when you got the, hey, we're going to dismiss the case notice in May, you didn't seem to take any action for the 45 days that elapsed between the notice of intent to dismiss and the date the case was dismissed. Only
I don't know that we got that notice of intent to dismiss. Let me take a look.
I'm sorry?
I don't know that we got that notice of intent to dismiss, Judge. Let me take a quick peek. It seems like sometimes we get them and it seems like sometimes we don't. So.
What do you see?
Yeah, no, we did not get the notice of intent to dismiss. We didn't receive.
Do you have the physical file in front of you? Or are you looking at a computer screen?
I look at my screen because anytime we get something in, it gets scanned into our system, so that I check our system and I look at everything that's scanned in. So anytime, because you guys just send those little itty bitty cards that are easy to lose.
Yeah,
so
they're postcards.
So we scan them in because we don't want to lose track of them, those itty bitty cards. So those are scanned in as soon as they come into our office. That's our process.
Okay. Well, anyway, that's why the default was not entered. The SCRA report was not provided.
Okay.
And then there was no response to the notice of intent to dismiss. Hence, we move forward with dismissal.
Judge, do you have the physical file with you?
Yes, I do.
In your physical file, did everything come to you? I mean, is everything in that file? Are there two like proposed default judgments or any defaults, or what do you have in your file, Judge?
I have your motion to set aside the dismissal together with the exhibits.
But nothing.
And I have the proof of service from mailing. I have the proof of posting by your court officer. And then I have received on June 23rd which of course is after the case was dismissed, SCRA report that came in with your June 23rd request for default. So,
Gotcha.
all right, so here's what I'm going to do. I'm going to grant your motion to set aside the default. I'm sorry, to set aside the dismissal in this matter.
Mhm.
And I'll let you file let me see, I had what?
You want us to send a default?
No, you have the default here.
Mhm.
Okay, I'll grant the motion and I'll enter the default. We send out the notices of intent to dismiss for a reason. The whole concept is, we're not saying who's at fault. It may be us, it may be you, it may be the post office, it may be bad luck, we don't know. We're saying to you, there's a problem, plaintiff, with your file. And you need to have, because I know you guys look on the internet at our register of action. You need to have some kind of in-house routine so that when these things are sent out, somebody acts on it.
Judge, is with the default that you're granting today, in terms of entry of a default judgment, do you want that by motion? Can we submit, say, a default judgment under 7 day? Can we, how do you want us to proceed in light of all of this?
Well, you need to do it by motion. The 7-day order, remember, is a memorialization of something that the court has ordered. And the only thing.
Yeah, you're only ordering the default.
Setting aside and entering the default.
Okay. Okay. I got it. I gotcha.
Okay?
I got you, Judge.
But you know, a lot of this could have been avoided. You have, I know you have some kind of routine in your office that says, hey, we sent these guys a default package on whatever it is date.
Mhm.
Is it back yet?
Well, here's what the story is, Judge. You only see the ones where there's these hiccups on either side. You don't see the ones where if we get it and we cure it, you know. These are the ones that you see the hiccups.
Right,
So
I understand that.
it's just a distorted view of the process because it's just, we are just together on the hiccups.
Okay. I will send out the order, setting aside the dismissal and entering the default for the case in this matter. I note for the record that your motion is unopposed. Thank you, Ms. Trickarts.
Thank you, Judge. Have a wonderful day.
Your day, be safe out there.
You too. Bye now.